and welcome to episode 3 of the DMH Stallard Employment Group podcast. In this session, we're going to be talking about the government's recent announcement seeking to, as it put it, crack down on employers' use of fire and rehire. And that culminated in January of this year, 2023, in the announcement of a new code of practice. What does it mean for employers? Should we be worried about breaching the code? Does it actually address the behaviour that employees are most likely to experience here and that came to the fore with the P&O events of last year? And so lots for us to discuss today. And with me to discuss the subject of fire and rehire are Rebecca Thornley-Gibson, partner in the employment team, with over 30 years experience of seeing the good, the bad, and as she puts it, the downright ugly in employee relations. Rebecca has significant experience in the travel sector, which was one of the worst hit sectors during the pandemic and had to make quick and difficult decisions, including where fire and rehire issues needed to be considered. So she's well placed to talk through these issues with us. And Simon Bellum, again, partner with over 30 years experience of helping employers navigate around the complexities of the contract of employment. So we've got a wealth of experience with us to talk through the issue. So getting us started, Rebecca, I think we have to start with P&O. That's where everybody kind of comes to this more recently and what people will think of when they hear the government talking about fire and rehire, and it's really what launched all of this discussion about codes and changes. So there was a huge amount of attention from the press around that mass firing of staff without prior consultation. And understandably, a lot of people were angry about that. Could you summarise for us what actually happened and what the gap in the law is, I guess, is the key point that meant it wasn't unlawful?
Yes. Hi, Adam. I think the P&O ferries issue last year was a pretty shocking example of employee relations going completely wrong. So P&O made just under 800 of its seafarers redundant, and they did that with immediate effect, just over a year ago on the 17th of March last year. They didn't consult with the workforce at all. They, in fact, announced the redundancies on a pre-recorded video call to all of the staff, and they announced plans to move to a new operating model using third-party agency workers to crew the ships. And as you say, Adam, there was so much attention about this particular situation. A lot of attention, obviously, from the employees itself, from the unions, from the press, but the government were incredibly cross about P&O, effectively just saying the legislation is there, we are not going to comply with it at all. We have made a commercial decision. We're going to pay compensation to our employees in lieu of following our statutory obligations. And the government was so cross that they called for the P&O CEO to attend the Transport Select Committee about a week later. So pretty swift action. But after the initial concerns and threats of criminal action against P&O for failure to notify that they were making redundancies to the Secretary of State, there was then probably a bit of a damp squib moment where the Insolvency Service, who can take criminal prosecutions against companies that fail to notify of redundancies, had advice to say, well, look, we've got a 50-50 possibility of a prosecution here in respect to the failure to notify. It's not enough. We're just going to let this go. There were so many issues in the P&O situation involving jurisdictional matters, rights relating to seafarers that are different to rights relating to land-based employees, effectively, redundancy consultation, collective consultation, unfair dismissal issues. Ironically, however, fire and rehire didn't really appear in the P&O case, even though, as you said, Adam, the consultation that we're seeing at the moment on fire and rehire seems to be ignited by the P&O case. And I think it's just a reaction, really, of the government saying we are not having large corporates completely ignoring good employment practice and legislation, and we are going to put in place steps to prevent that in the future. So yes, P&O wasn't really a fire and rehire case, but everybody thinks it was because they just fired people.
Yeah.
The only people that they were hiring were completely different people, as in the agency staff.
Yeah, that's a great intro. Thank you, because it does bring out this big point, which is actually P&O is a pretty unusual, exceptional set of facts in terms of what actually happened. Isn't really fire and rehire. The seafarers' point that it's quite unique, and yet the response and the publication we've had about fire and rehire is dealing with a more common issue actually, which hasn't had the same amount of press attention, and it's something that's more likely to be experienced by workers in England and Wales. Simon, I mean, understandably, a lot of people were angry about what happened with P&O. I wonder whether really what's happened is the government sensed the perception of weakness in the legislation and perhaps in its response, in that aside from the public relations, so the PR damage, the public probably sensed that there wasn't really any repercussions for P&O, and the government's language talks about cracking down on unscrupulous employers. That does what the government is proposing to do really live up to that strong rhetoric? What is the government actually doing, or perhaps saying it will do to discourage employers? What are the threats?
Yeah, hi, Alan. I think that the rhetoric is noisy from the government, and I think that that is a reflection of the publicity that arose from P&O. So the language is quite emotive. It's crackdown and fire and rehire and references to P&O. But I think, as we've been talking about, the code of practice really is looking at a different issue, which is about the practice of employers to fire and then rehire the same staff. And I think that the government's proposals are a measured response to something which has been happening over a long period of time. And that is that when the idea of being able to change terms of employment through firing and rehiring staff was first introduced, most employers were pretty tentative about how they would go about it. They'd be worried about the risks of tribunals criticising them. They'd be worried about the risk of tribunals not accepting the business reasons for the change in terms of employment. But over a period of time, employers have got bolder and bolder. And I think now it has increasingly been used as a threat, as a tactic to force through changes in terms of employment. I think employers basically say to themselves, right, well, provided we've got a reasonably decent business reason for changing the terms of employment, and provided we go through some sort of process to suggest that we tried to get agreement of staff to the change in terms before we imposed it through fire and rehire, it's pretty unlikely that we're going to get criticised by an employment tribunal. And that's what this proposed legislation does. It says, no, it's the entitlement to change terms through the process of rehiring and firing and rehiring has been abused. It shouldn't be used as a threat, as a tactic to force employees to agree to a change in terms. And critically, that the consultation has got to be meaningful. And the way in which the draft code of practice, as it now stands, describes what good consultation should look like is much more specific than previous codes of practice in relation to consultation. It does the obvious, which is to say, well, consultation must be in good faith and transparent, etc., which you see in all codes. But it goes a bit further than that, and it says that, well, employers got to be searching for compromise if the employees aren't initially willing to agree. The employer has got to search for ways to mitigate the impact of the proposed change. And it, importantly, If an employer fails to comply with the code, then it can be taken into account by tribunals in considering claims such as unfair dismissal. And I'll be very interested to see how tribunals approach the matter. I suspect that there will be many claimants and claimants' representatives who seek to rely on the specifics of the code, which, as I say, is reasonably detailed, the draft code, as to what an employer should be doing, to say, well, look, my employer just didn't consult properly. They didn't comply with the provisions of the code, and therefore this process is unfair.
Mm.
So I think that the government's actions are pretty tough. I think that they do potentially have teeth, depending on what the code ultimately says. I think it is a reasonably tough measure to tackle what is a long-standing issue, which has been highlighted by more recent events such as P&O.
Yeah, thank you. I mean, the thing that I've been reflecting on this is, Rebecca, I don't know your thoughts on this, but the code obviously sets out, as you say, Simon, that's a really helpful summary of this very specific aspects of it. And it's clearly talking about consultation that's meaningful. And one of the things that came out of P&O was, if you're an organisation, you can take a decision that it's going to cost us money, but we're prepared to just not follow the steps, and that actually that's a fairly binary decision, and there were no real repercussions. What do we think? There's an uplift, I think, to the awarding tribunal is the proposal, which we're familiar with from the disciplinary grievance procedure code, 25%. But do we think that's enough of a threat, Rebecca? 25% uplift. But what about? I mean, I'm thinking, does the code? And Simon, you may be able to help with this. Does the code talk, or is it going to end up in a place where it says the probability of reinstatement or re-engagement will be much higher? Because you often think about cases, you think, well, what, we have 1% of cases reinstate or re-engage an employee, but is that the thing that will really change a big organisation who's budgeted for this decision? If actually, it's not just money, they might all be ordered back to the shop floor, so to speak.
Yes, I mean, that really would be the punitive stance for a tribunal to take, because at the moment, I think that just awarding, potentially up to 25% as a punitive uplift on compensation for the employee isn't going to cut it, because the code doesn't stop an employer going ahead and making changes. It just applies at the moment that uplift if an employee decides that they're going to take some external legal action because they're not happy with what has happened. And I think, when you have legislation that doesn't stop an employer doing something, they will always take a commercial decision as to whether economically it's actually worth breaking the law. Yeah. But if they felt that there was the risk of a reinstatement and they had been told.
Yeah, I mean, I guess that maybe that's the point, Rebecca. I'm being overly ambitious and unrealistic about this idea of reinstatement, re-engagement. You've been in the tribunals, both of you, very many times. I've seen remedy hearings. There's the point you made about the individual doesn't want to be reinstated. The tribunal looks and goes, this relationship is now acrimonious, has broken down. Maybe that's the thing, Simon. It's in reality, how likely is it that reinstatement or re-engagement is going to be something that either party wants? So what's the point in threatening it as something that now is much more real and present as a threat for employers?
Well, I don't know. I think that it is a potential threat, because the relationship, has it broken down? Employers have said, we want to change your terms of employment. We want to introduce some change into the way you work. Employee says, I don't want that to happen. They can't agree on it, dismissed, and the employee brings a claim of unfair dismissal because they don't accept the offer of rehire or re-engagement. Where's the breakdown in the relationship? They've just had a disagreement over what the terms of the relationship should be. And so I think it is realistic a tribunal would say, well, it is practical to order reinstatement. And as I say, the code of practice ought to be taken into account by the tribunal in taking its decisions. So I think that, yeah, the threat of 25% uplift is part of the teeth of the legislation. But I also think the increased risk of a tribunal saying, no, this was an unfair dismissal, and as you're suggesting, the risk of an order for reinstatement, are things that are going to make employers think harder about how they go about these processes. As we're saying, reinstatement is probably the ultimate nightmare for most employers.
I think as well, Simon, if you look at the purpose of the code, it is very much about taking all reasonable steps to explore alternatives to dismissal.
Mm-hmm.
And those reasonable steps have to be taken even after changes have been made to see if those changes are still needed as well. So if an employment judge looks closely at the purpose and they say, well, an alternative to dismissal now would be reinstatement, and therefore reinstatement is aligning with the purpose of the code, that might encourage more employment judges to agree to a reinstatement. But as I said, as I said before, employees have got to want that. It's got to be a mutual decision.
Yes, or say that they want that for the purposes of upping the pressure and heat in a set of proceedings that they suspect they'll never get to tribunal over. We'll have the usual settlement. But that is really interesting, because we're talking about a sort of retrospective unraveling of the, as the government described it, unscrupulous plans of the employer, that these can be unravelled before the employer's eyes. And that's going to be interesting to see, isn't it, how much of that element remains and is emphasised in the final publishing of the code. Simon's point was well made about this coming in the context of a greater degree of comfort for employers about going to groups of employees around their terms and adopting the approach of, well, if we can't agree, we will hire and refire. And of course, we had the Woolworths case law and litigation around the issue of establishment, because often the big threat here, and the thing that we as lawyers advising our clients about, is obviously collective consultation is a big, potentially very expensive litigation. Woolworths then said, well, no, each independently operating part of a business could be a separate establishment on this issue of the trigger of 20 or more redundancies, which is in this broad sense. And then obviously you look at 20 or more in a 90-day window. Is this just going to be, picking up that point, Rebecca, is this just going to be relevant to employers in that large scale scenario? We think of P&O was massive. Simon said 300. Is it going to be only applicable to the 20 or more terminations in a single establishment?
No, I mean the code doesn't put any numbers on the people that will be impacted, the employees that will be impacted. So you could have a situation where an employer is seeking to remove, let's say, a shift allowance for one employee, and they would still have to follow the code in respect of only one employee who may be impacted by a particular change. So
this is
I
really
think
important, isn't it? Because
sorry,
because perception will be this is about P&O. It's large scale changes of terms and conditions. I, as my employer, talking to this sales team of 3, don't need to worry potentially. But what you're telling us is very clearly, no, the code has no wordings that say that's an excluded, that doesn't count, you don't have to worry about it. You've said it could be just one person.
Absolutely. In reality, you can imagine a small employer not knowing about this code, not knowing about a lot of codes in employment law. A small employer seeking to make a change, getting cross with the employee that doesn't necessarily, agree to those changes, and saying, well, take it or leave it situation. This is what is going to happen. If we go back to the pandemic, where employees were having to take pay cuts or potentially lose their job, this was happening an awful lot. And yes, sometimes with large employers, but often with very small employers that had to say to their employees, even with potential furlough, I may still have to cut your salary. And I think it's the small employers that are going to be quite shocked that there's this extra layer of um, compliance that they have to go through before they can make changes. In reality, this is going to be used by unions as a great negotiation tool, and employers are going to be beaten quite hard by those unions if they see that the code isn't being followed, on a line by line basis. And I think what's interesting about this code is this need for continued review of the changes after changes have actually been made, to monitor the impact of the changes. What on earth is that going to look like? Is an employer going to turn around, 12 months on and say, well, we made these changes a year ago. Do we still need to make these changes? Here's our note. No, we don't, carry on. That's going to be really difficult, I think, in practice, how you monitor the impact. For how long do you have to carry on monitoring? What evidence do employers need to say that they have complied with that aspect of the code? I think that's a really tricky one. But it is a draft code at the moment, and those are the sorts of questions that are likely to be raised in the consultation over the code.
I came at this on that point you made about the unions, wondering, probably being overly cynical, whether that part of this was also the objective of the government was also around taking away some of the power of the unions. I just put it out there, Simon. I don't know what you think, but the idea that if you've got a code that protects you, that you can enforce individually in tribunals or as a group of employees together, I'm not sure that the objective will be achieved for the reasons Rebecca mentioned. But is it really saying it's further moving away from a unionised environment and the power of the union? Because these are things that could be much more obviously put in the hands of unions for large-scale scenarios. What do you think, Simon?
Well, the draft code as it stands stipulates that the consultation should be with union, where a union is recognised, and it should be with representatives, where you've got a representative body which is already identified as the appropriate body for consultation. And that's a parallel to other consultation processes, such as TUPE consultation. And it's only if the unions aren't there, or if the existing appointed reps aren't there, that the employer then goes and considers consultation with the individuals. And even then, the code is referring to a need on the part of the employer to consider whether the individuals should be asked to nominate representatives, effectively to hold elections. So it doesn't go as far as the existing TUPE and redundancy consultation legislation, which requires employers to set up elections. But it suggests that, well, if there's no existing trade union or appointed reps, then go to the individuals, but do consider whether they should be holding an election to appoint representatives.
Yeah, that's a point that comes out then in terms of what the implications might be for employers around appointment of employee rep groups. I mean, we saw in the pandemic, didn't we? Certainly saw with clients, you started to have a greater focus on those when you were dealing with health and safety matters to implement in response to COVID. Maybe, Rebecca, what do you think? Maybe that, depending on what the code looks like in the end, one step change you might see, well, maybe further evolution is into employers who aren't in a unionised environment, saying we're clearly going to need a good functioning employee rep group, not least on that point you made about, well, how often do we go back round reviewing these changes and saying, well, they didn't really work, so we're going to rewind one or change another again?
Yeah, no, absolutely. I mean, I think the code it's another example of shining a brighter spotlight on the employee voice in an organisation and the involvement of the employee in key decisions that are going to be made that impact on them. So where you have that, sometimes, employees are more comfortable if they have an internal employee representative committee, staff committee, call it what you want. Not all employees want a unionised environment, want to join a union, but they do still want a voice within their organisation. And codes like this that require that dialogue, form part and parcel of providing that extra voice to employees.
Yeah, indeed. I'm going to ask you in a minute, but when we wrap up, just the impossible question of whether you think, and maybe in what way, this is going to make a material difference to the unscrupulous employers that the government describes them as. But before we do that, Simon, what are the key dates? When are we actually going to see something of real binding substance, or even just that's not a draft anymore on this? When can we expect things to actually change?
Well, we don't know for sure. The government has called for responses to the draft code by the 18th of April. And once it's got those responses, it's going to consider them and then publish the final code. And the consultation says that it will be introduced when parliamentary time allows. So that's anybody's guess, really. I mean, my guess is that it will be during the currency of this parliament, so sometime before the end of 2024. It's conceivable that it might be one of these things that gets kicked into the long grass. There might never be time, but I suspect we will see something, and I suspect that it'll be towards the tail end of this year or 2024. But it is guesswork as far as parliamentary time is concerned. There's plenty of other things on the agenda, as we know.
Thank you. Right, so to wrap up then, final thoughts from each of you, please, on whether the code is going to make a material difference to the way that unscrupulous, as the government calls them, employers approach terminating and re-engaging, if and when it does come in, of course, because as Simon said, we don't quite know when that will be.
Yeah.
Shall I kick off?
I think that, yes, kick off, Simon.
Well, you're both keen, you see. I thought this was going to be the tricky bit.
No, off you go, Simon.
I've forgotten what I'm going to say now. Well, I think that the code will make a difference. It will make employers think much more carefully about the process that they adopt. I think they're likely to be much less aggressive and gung-ho, at least on the face of it. And I suspect that there will be many more challenges which are based on inadequate consultation than we've seen in the past, where people have been subjected to fire and rehire.
Yes, I mean, it will certainly make some difference. I don't think in the short term it will make a huge difference for unscrupulous employers, because they'll be watching what the employment judges do in respect of the extent of the punitive measures that they can put in place. So I think we need a few decisions first before we can say whether the code has been effective and whether it's achieved its purpose in respect to that extra layer of consultation.
I note that there's a slight hesitation on how much of a change it's going to make. Rebecca, maybe a bit like me, we'll wait and see exactly how the truly unscrupulous respond. But of course, all our listeners are not unscrupulous in any way, shape, or form. So Simon is, I'm sure, right that the code will have the impact, and we need to obviously watch it develop to its final form, hopefully before the end of this current parliament. Right, thank you both very much. And all that remains for me to say is don't forget to follow our podcast on I think LinkedIn and the website. You can find that. And there'll also be a summary of the points we've discussed with some links to a reading list of materials as well on the website. Thank you, Simon. Thank you, Rebecca. And thanks everyone for listening.
Thank you.
Thank you.